Hi, my name is Zach McGee. I'm the chairman of New Media Legal Publishing, the sponsor of this CLE program. The presenter of this program is Andrew Struve. Andy was a brilliant, experienced, and highly successful litigator here in Southern California. On a personal level, he was also a warm, caring, and infectiously funny human being. Sadly, Andy passed away in July 2023 after a brief illness. The program you are about to watch was recorded a few years ago, but I've confirmed that the content still reflects the current state of the law on this topic. Reposting the program allows lawyers like you to continue to benefit from Andy's wisdom, and it allows those of us who knew Andy well to keep him around us for at least a little bit longer. I hope you enjoy it.
Hello, I'm Andrew Struve. I'm a trial lawyer in Southern California. We're here today to present part 3 of a program on famous and infamous ethical breaches by attorneys. For those of you who are letting out a groan knowing it's part 3, the reason it's part 3 is we got such a favorable reception to parts 1 and 2. After careful consideration, we thought, heck, why not? We'll do it again. So that's why we're here today for an hour. I'm told this will qualify for Ethics MCLE, as I think it should, so you'll get that too. And this is not going to be like Godfather Part 3. I think this is actually probably the candidates that we have offered for your consideration today are probably a better batch than in either of the first 2 programs. So I'll commend it to you, and I hope you enjoy it. We also have a similar presentation on judges, having done 3 hours of focusing on attorney-alleged misbehavior. We carefully reflected back on some of the judges we have known in our careers and thought that it simply wouldn't be fair to leave them out. So we'll be getting to them in due course, and I commend that to you if you like today. A couple of quick words of introduction. There's a score sheet that comes along with this program. It's set up somewhat like a bingo card. It lists some of the more common ethical standards in one column, lists the names of our subjects today on the other axis. And if you'd like to play along, you can just check the boxes on what you think each of these individuals may have satisfied with respect to ethical violations. The cases that we selected, just by way of explanation, we were careful to select cases where the subject matter was fairly well baked, meaning there were not a lot of disputed issues of fact that remained. Frankly, there often weren't any, and a criminal conviction after a trial or a voluntary resignation from the bar in face of charges seemed to us to be a pretty good standard, and that's what in most of these cases you will see. One quick word about any perceived gender bias. You'll find that our subject matter today is primarily white males. I will leave it to the audience and to any social scientists among you to decide why that might be. I would offer that during the decades in question, most of the lawyers were white males. The social scientists among you might think they have a higher propensity for dishonesty, being males, which is true with some crimes, but that's neither here nor there. I just don't want you to think that there was any bias, either intentional or unintentional, on our part. So with that as a prelude, appearing above my left shoulder, hopefully, will be a picture of Joseph Peter Ganim, our first subject of discussion today. For those of you in Connecticut, you'll know him as Joe Ganim. He was the mayor of Bridgeport, Connecticut, for a number of years, from 91 until 2003. He also ran for governor twice and lost both times. And by all accounts was a popular fellow in Bridgeport. When he ran first for mayor, he accused the incumbent of making the city a symbol of urban failure with a bankruptcy filing that drew national headlines. At the time that occurred, urban and municipal and governmental bankruptcies, for the most part, were very, very rare, and they were under a very little used section of the bankruptcy code. But what's interesting about the Bridgeport case was it served sort of as the model for the later bankruptcy of Orange County, California, after a very unfortunate investment scheme by the county's then administration. So, with that as a prelude, so Ganim was a popular mayor. He was also an activist mayor. He filed a number of litigations with a number of other U.S. cities, such as New Orleans, Miami, and Chicago, against the handgun industry, arguing that the industry had failed to use technology to make handguns safer, and that this led to handgun violence. These suits, many of them in the Eastern District of New York, for the uninitiated, Brooklyn, found some judicial favor in the federal court and led to the later cases against the tobacco industries. And in 1999, Joe Ganim received he was one of 3 American mayors to receive the City Livability Program Award from the U.S. Conference of Mayors for addressing urban decay and for engaging in city beautification. All that was fine, but in March of 2003, Joe Ganim was convicted on 16 federal counts, one of racketeering, extortion, racketeering conspiracy, and bribery, 2 counts of bribery conspiracy, 8 counts of mail fraud, 2 counts of filing a false tax return, 2 silver rings, and a partridge in a pear tree. Ganim was acquitted on 6 other counts. He surrendered his law license upon conviction, so no longer a lawyer. And the charges came out of what was alleged and proven to be his role in a 6-year scheme to shake down city contractors for more than $500,000 in cash, meals, clothing, wine, and home renovations. Took pride in his home. And then 2 weeks after his conviction, he resigned from office. Footnote, for anybody who watched the earlier programs or was a student of history, you'll recall that disgraced first Vice President Richard Nixon, Spiro T. Agnew, had been a city of Baltimore executive and later county executive, and he had engaged in the same type of alleged conduct, namely requiring substantial kickbacks from contractors in exchange for infrastructure projects, right? So all of this is reasonably unremarkable. Ganim was sentenced to 9 years in prison and to fines and restitution. And the judge who sentenced him said that his crimes were the stuff that cynicism is made of, that's a quote, and determined by clear and convincing evidence, apparently relevant to the sentence imposed, that Ganim had lied to the jury when he denied any knowledge of fee-splitting deals and other incriminating evidence, end quote. And so garden variety governmental fraud wouldn't make our head list today except for one thing. So convicted in 2003, 9 years in prison. Flash forward, December 1, 2015, Joe Ganim is sworn in once again as the mayor of Bridgeport, Connecticut. So I'll give you a second to gasp. There you go, you're done. And then he got reelected to another term in 2019, and he's currently the mayor of Bridgeport, Connecticut. When he was reelected, the New York Times, and this is a quote, reported his election victory as, and I quote, "a stunning return to public office, remarkable for its sheer audacity, coming after a widely publicized fall from grace," end quote. For those of you in Connecticut, you can hearken back to Governor Rowland and some others. And anybody who's sitting here wondering what the heck is going on in Connecticut, I don't blame you. Anyway, so what's interesting is that Ganim is has been for a long time trying to get his law license reinstated. It's been a long time campaign on his part. He has appealed to various courts. In September 2012, a 3-judge panel of Connecticut Superior Court judges who hear such matters rejected a recommendation from the state bar that his law license be reinstated. And the court said, and this is a quote, "Allowing an applicant to be readmitted to the practice of law following a conviction on 16 counts of racketeering, conspiracy, extortion, mail fraud, bribery, and filing false income tax returns without any apology, expression of remorse, or explanation, and with only a vague acceptance of an unspecified event, simply would set the bar for readmission too low in the state, and we are unwilling to do that," end quote. Undeterred, Ganim continued on his quest for his law license. As of April 20th, 2021, it's continuing to this day, and we shall see where it takes him. And if you live in Bridgeport, all right. Our second subject of discussion today is a lot more famous than Joe Ganim, and it's G. Gordon Liddy for his role in the Watergate conspiracy. And for those of you who remember, back in 1972, he had organized and directed alongside E. Howard Hunt the burglary of the Democratic Party national headquarters in the Watergate Hotel and Office Complex in Washington. By way of background, you probably surmise, given our program's topic, Liddy was also a lawyer and an FBI agent. He went on, after resigning the FBI, to be a chief operative in the White House Plumbers Unit in the Nixon investigation. The Plumbers Unit were essentially in charge of dirty tricks, and the Watergate break-in was one of those dirty tricks. During his earlier years in the FBI, he became the youngest bureau supervisor at the FBI headquarters in D.C., which is it's a sort of premier role. He became part of J. Edgar Hoover's personal staff, became reportedly J. Edgar Hoover's ghostwriter. I don't know that to be true. He did also manage to establish for himself, shall we say, a history of recklessness. He fired a gun in a courtroom once that he was appearing in, I believe, to testify. And he was also called on the carpet in 1957 for running an FBI background check on his future wife before he married her, which he later referred to when questioned about it. And this, too, is a quote, "It was purely a routine precautionary measure," end quote. Okay. Before he left the FBI, he obtained his admission to the bar, and the Solicitor General Archibald Cox was was actually the person who moved for his admission to the United States Supreme Court, which is a fascinating footnote if you think about what happened to Archibald Cox then during the so-called Saturday Night Massacre during the Watergate investigation. After leaving the FBI in 1962, he became the county district attorney in Dutchess County, New York. Kind of a fun fact about G. Gordon Liddy. So he's serving as the public prosecutor in Dutchess County. For the uninitiated, Dutchess County is about 100 miles, 80 miles north of New York City, straight up the east bank of the Hudson River, all right? And in Dutchess County, there's a little town near Rhinebeck called Annandale. And in Annandale, there's a little liberal arts college still there called Bard College. And in 1969, two guys named Donald Fagan and Walter Becker were undergraduate students at Bard College. And they were caught up in a drug raid at the Bard campus that was inspired, directed, and led by Dutchess County Attorney G. Gordon Liddy. Why do we care? We care because Donald Fagen and Walter Becker went on to become founding members of Steely Dan. And they wrote that they'd go back to Annandale, right, where their college was, quote unquote, when California falls into the sea. So that's what G. Gordon Liddy did to Steely Dan's undergraduate experience. So we'll go back to 1972, the plumbers unit in the Nixon administration, and there were a number of plots operated under something collectively called Operation Gemstone. Among the more remarkable, there was a plot to kidnap anti-war protesters and transport them to Mexico illegally during the Republican National Convention, which was planned for San Diego. There was apparently a plan of luring Democratic campaign officials to a houseboat in Miami where they were to be photographed in flagrante delicto with hired prostitutes. Attorney General John Mitchell rejected a number of these. That's a pretty high bar if you follow John Mitchell's career. But some were given the go-ahead, including the break-in of Daniel Ellsberg's psychiatrist's office in Los Angeles after Ellsberg had leaked the Pentagon Papers to the New York Times. And so subsequently Liddy was instructed to break into the Watergate complex, which he did. He was sentenced to a 20-year prison term, which he began serving in January of 1973. And in 1977, President Carter commuted that sentence. Say what you will about Carter, but I think he shared with President Ford a desire to put the Watergate era behind us as quickly as possible. Now, obviously, after the Watergate connection and the prison sentence, Liddy was no longer qualified to practice law and was no longer a member of the bar. So our next subject today, I'm going to be referring to notes on because this guy, frankly, is really beyond belief. And the amount of conduct he engaged in over a span of time is really, frankly, mind-boggling. This is Kwame Kilpatrick, and it truly ought to make anybody's top 10 list for an extensive career of political corruption in the United States history. And Mr. Kilpatrick was also a lawyer. He came from a family of politicians. His mother had served for a long time in the Michigan State Legislature. She went on to be a congressperson from Michigan. And early in his career, her son Kwame Kilpatrick, Mr. Kilpatrick, essentially inherited his mother's seat through an election. And so anyway, in 1999, Mr. Kilpatrick, by the way, is a young man, considerably younger than I am. And when you think about that, he has really accomplished a lot in his professional life, most of it bad. In 1999, he received his JD from a school that I won't name out of fairness to the Michigan State University College of Law. Just kidding. His father had been a semi-pro basketball player. He was a very charismatic guy, Kilpatrick. 96, again, as I said, he was elected to the Michigan House of Representatives. And his campaign staff was mostly made up of old friends. The reason I mention that is that was a consistency throughout the entirety of his political career. At the age of 31 in 2001, Mr. Kilpatrick was elected the mayor of the city of Detroit. Anybody who has a passing familiarity with the city of Detroit, it can sort of be summarized as this: back about 175, even 60 to 50 years ago, it was truly one of the most important and successful cities in the United States. It's suffered from a number of reversals, loss of manufacturing and white flight and those kind of things. And now the city population has declined dramatically. The city's full of vacant properties. The properties that are still residences are kind of widely dispersed, and there's been under consideration many things such as shrinking the city limits and consolidating the population. So anyway, back to 2001, Kilpatrick's the newest mayor, 31 years old, and during his first term, he used city funds to lease a Lincoln Navigator for use by his family. He used his city credit card to charge thousands of dollars worth of spa massages, extravagant dining, and expensive wines. During the same time, he closed down the Belle Isle Zoo and Belle Isle Aquarium, much beloved by children for budgetary reasons. 2005, Time magazine, ahead of the curve and obviously with a better crystal ball than the voters of Detroit, pronounced him, did he make number one? One of the worst mayors in America. 2005, 4 years into his mayoral career. You can see I'm holding up a thick stack of papers. That's Mr. Kilpatrick for you. I can only imagine what his file looks like. Okay, fall of 2002. He's now been mayor for about a year and a half. It was alleged that Kilpatrick had held a wild party involving strippers at the Manoogian Mansion. For the uninitiated, the Manoogian Mansion is Detroit's version of New York's Gracie Mansion. It's a stately property which is the official resident of the mayor. And I'm looking at a photo of it. It's a very nice looking house and with a storied history, and it probably would have burned itself down if it had known what was going on. So anyhow, the incident that occurred that night at the Manoogian Mansion was initially, shall we say, swept under the rug, but some former members of then Mayor Kilpatrick's security protection detail came forward, and so their story was that while this stripper party was going on, Mayor Kilpatrick's wife came home unexpectedly and unannouncedly and physically attacked one of the exotic dancers, and this prompted an internal investigation by the Detroit Police Department of the Executive Protection Unit. And Kilpatrick denied any wrongdoing. The Michigan Attorney General and the Michigan State Police investigated this and found that no evidence of any party had taken place. Not no evidence of wrongdoing, get me. No evidence that a party had occurred, okay? And so then some officers, these are law enforcement officers of the Executive Protection Unit, were fired by the Kilpatrick administration, and they alleged that this was in retaliation for bringing to light the stripper party that the State Attorney General and the Michigan State Police had found never happened. And they filed a whistleblower lawsuit for being fired in retaliation for investigating the party that never happened, and they were awarded $6.5 million. Strike that. They settled with the city of Detroit that had just closed its children's zoo and children's aquarium for $6.5 million. Okay, so you'd think the party would end there, right? Oh no, the party was just beginning. The I guess I'll have to say alleged stripper who was allegedly attacked by Mayor Kilpatrick's wife in the fall of 2002 at the Manoogian Mansion party that never happened. In April of 2003, she was in a car near the intersection of Roselawn and West Outer Drive in Detroit, and she was shot multiple times with a .40 caliber Glock pistol and killed. And they never found the person who shot her. However, and I'll let you draw your own conclusions, the Glock 40 caliber that was used to kill the exotic dancer from the party that never happened, the weapon was the same exact model and caliber officially issued at the time to the City of Detroit Police Department. And there was quite a bit of of investigation during the death of this poor woman, that they believed that this may have been a deliberate hit by members of City of Detroit law enforcement. And keep in mind, we're only a year and a half into this guy's term at this point. All right. By the way, after that $6.5 million, which I have to correct myself, actually was a jury award. It may have settled after the award in lieu of appeal, but there was a jury award awarding these two fired officers $6.5 million. Then Mayor Kilpatrick held a press conference. He said, "There's race in this, and we run from it in this region. And I think it's impossible for us to move forward as a region without confronting it head on. But I don't want what has happened in the past 24 months to be erased by what happened in the last 2 days." So then it goes on, and local newspapers in Detroit, the Free Press, the Detroit News, sued under the State Freedom of Information Act, seeking details about what led the city to the $6.5 million resolution. And the documents that were produced ultimately revealed text messages that included a strategy by then Mayor Kilpatrick and the city law department to hide text messages that contradicted the sworn testimony of Mayor Kilpatrick and others. And this goes on and on. The text messages were a violation of city regulations because, of course, they were city-owned devices that were used. There were more charges filed against Mayor Kilpatrick, still in office, in his career in 2008, including physical attacks on sheriff's deputies who were acting in the line of duty. Kilpatrick pled guilty to 2 counts, felonies of obstruction of justice and assault. And time doesn't permit me to go on and on. There were instances in 2007 of city-paid vacations for Kilpatrick and his family to the La Costa Resort and Spa in Southern California. There was Elise DeVille's summer camp for his children, yoga, golf clubs, and other things. $180,000 worth of travel, rooms, and gifts from a company seeking investment from the city pension fund. More corruption charges, extortion, bribery, and fraud in 2010. And so ultimately, Kilpatrick was found guilty of all these charges. He was sentenced in 2013 to 28 years in prison, which he began to serve. But lest you feel charitable towards Mr. Kilpatrick, in 2021, less than 12 hours before he left office, then President Donald Trump commuted Mayor Kilpatrick's sentence, the White House citing the fact in mitigation that Mr. Kilpatrick, while in prison, had been giving public speaking classes to inmates and teaching Bible study. So there you have it. He's still a convicted felon, not eligible for office until 2033, and I'm sure we'll see him again in 2034. All right, so our next subject of discussion today is former Congressman Pat Swindoll. There'll be a picture of him over my shoulder, I assume. He was, during the time that he was in Congress from 1985 to 1989, as a member of Georgia's 4th Congressional District, which for the uninitiated is the eastern suburbs of Atlanta. So Mr. Swindoll served two consecutive 2-year terms as representative. His wife was a former cheerleader. She's not alleged to have done anything wrong, but she and Representative Swindoll were called the Barbie and Ken of the congressional circuit at the time. In 1984, there was a re-election. In 86, but in 88, Swindle was indicted. And by the way, of course, he's a lawyer. That's why we have then Representative Swindle here today. He was indicted on 10 counts of perjury relating to a money laundering scheme. And the details of the money laundering scheme were recorded by an undercover IRS agent who was posing as a representative of the Colombian drug cartel. And the Colombian drug cartel obviously wanted something from Representative Swindle. I know not exactly what, but you can take some wild guesses, and you're probably right. And so Swindle was looking for an $850,000 loan to finish building his luxury home, and the Colombian drug cartel was to supply him with the $850,000 loan, and made it clear to him the loan would not have to be repaid, and that this was just going to be a cash washing or money laundering operation. And so Swindle went ahead and suggested the best way for the Colombian drug cartel to accomplish this and thus pay for the completion of his home was if the drug cartel set up a phony mortgage company to funnel the money through, and then gave Swindle a mortgage that was never to be repaid. A grand jury investigating the broader operations of the Colombian drug cartel had been convened. Swindle was hauled in to testify before this grand jury, and he repeatedly denied under oath to the grand jury any knowledge that the funds he was to be receiving came from the Colombian drug cartel. The slight difficulty for then Representative Swindle was that the IRS had this all on tape during the time that the discussions first took place. And so the perjury charges we mentioned were brought. He was convicted by a jury on 9 counts. He was sentenced to a year in prison and a small fine. This was overturned on some of the counts later by the 11th Circuit Court of Appeals, but the U.S. Supreme Court upheld the remaining 6 charges. And Swindle actually served most of his sentence, in federal court, unlike in state court. You can get good time reductions and those kind of things, but you don't get a huge discount on your sentence like you do in some states, such as California. So anyhow, in 1995, he's released, and he became a religious talk show host on the Providence Broadcasting Network, and it all ended there. No, it didn't all end there. 2009, about 14 years later, here's Swindle again. Here he is indicted again by a Fulton County grand jury. He and 2 of his employees were indicted for making illegal campaign contributions to an Atlanta city councilwoman, and they were indicted for making false statements as the donors, because the other conspirators testified that Swindle was actually the source of the funds, and yet they were inaccurately reported on the campaign disclosure forms as having come from the individuals. And there were various other things, but they're not worth naming. He passed away at the age of 67 at his house. I don't know if it was the same house. Okay, we're going to go back in time a little bit. This is an interesting one because it shows that some crimes do have sort of a history of continuation. In other words, you can go from generation to generation with people, in our case lawyers, engaging in the same type of conduct. So this is Michael Ryburn. I don't know how he pronounced it. I think Ryburn would probably be accurate. Modernly, some people might pronounce it Rayburn. Lived from 1893 to 1982 in New York. He was a lawyer. He was a prominent Democratic Party politician. And he won many debating prizes. He was fraternity president. He practiced law in Syracuse, then moved to Washington Heights and Manhattan, and was an active practitioner of law and a member of the New York State Assembly. and he was endorsed by the then prominent Citizens Union. He served in the New York State Senate for another 3 years, and he was chairman of the Committee on Labor and Industries for much of that time. In 1927, he was indicted for larceny. Charges were dismissed. But in 1935, the New York Supreme Court Appellate Division, which in New York is the lowest level of the trial courts, that's where your cases begin in New York. He was disbarred for unethical practices, and this was described in a quote as the conversion of money from others by false representations of large profits to be made from the purchase of real property about to be acquired for public purposes, end quote. The exact details are lost to history, at least to mine, but you can sort of imagine what one would do here if one were in politics. They would, find a way to acquire an interest either themselves or through others in certain land, and then they would inspire other people to buy it at what was presumably an otherwise steep price, based on the supposition that inside information was giving the purchaser reason to believe that the property in question would be acquired for use for whatever public purpose under presumably eminent domain or something of that effect. And then he was convicted of several things. In 1937, he was indicted for swindling 3 widows out of $10,000. Note to the audience, if you ever would like a sentence enhancement, perpetrate your crimes against the elderly. In the federal system, that will usually qualify, as in many states. He served time in the infamous Sing Sing prison in New York. Free fun fact: that prison got its name from the town in New York in which it's located, Ossining, New York, hence Sing Sing. And he never resumed the practice of law after the 5-year prison term that he received for those acts. Our next person to discuss today is C. Vernon Mason, and before I do that, smattered throughout our subjects today are a few people who believed, rightly or wrongly, that the bar proceedings that were taken against them, were taken out of retribution for the lawyers' political beliefs, or the often hand in hand with political beliefs, the individuals whom they represented. And they were of the opinion that they'd been overcharged or shouldn't have been charged at all. And Mr. Mason was one such person. He was a lawyer and civil rights activist from Tucker, Arkansas, and he'd been involved in several high-profile New York cases, including the famous Bernie Goetz subway screwdriver stabbing back in the 1980s. He was an ordained minister, but he was ultimately disbarred in 1995. And what had happened was, back in 87, Mason, along with Al Sharpton and Alton Maddox, were advisors to Tawana Brawley, who was an African-American teenager whom you may remember claimed to have been abducted and sexually assaulted by 3 white males. And a subsequent grand jury investigation determined that she had not, in fact, been abducted and assaulted as claimed, and that allegations that had been made against the district attorney's office with respect to that case were false. And there went on to be litigation over defamation that came from that. Now, what led to Mr. Mason's disbarment was not specifically that incident, that situation. What led to it was, officially by the New York State Appellate Division, First Department. That's the intermediate court in New York. The Court of Appeals is the highest. The Appellate Division of is the intermediate court. The court found in support of disbarment, 66 instances of professional misconduct with 20 clients over the course of 6 years as its rationale for the action, including repeated neglect of client matters, many of which concern criminal cases where a client's liberty was at stake, and failure to earn or refund unearned fees. The Brawley case was not mentioned anywhere in the disbarment decision or the statement of facts that resulted in that disbarment, but Mason repeatedly and consistently asserted that the ruling was intended to punish him for his role in that case. And now, a fellow you've probably heard of, truly a fascinating story, and one that's really disgusting in a lot of ways. Up on our screen, probably wearing a white cowboy hat, wow, we got that one wrong, is Fred Phelps, also known as Fred Waldron Phelps Sr. Now, Phelps died in 2014, but he was a minister and he was a civil rights attorney. He was also the pastor of the well-known Westboro Baptist Church, who was known for his extreme views against homosexuality and protests near the funerals of gay people, military veterans, and disaster victims whom he believed God had killed as punishment to these people for having bankrupt values and for having tolerated homosexuality. This is the fellow, if you may remember, during most of our audience's lifetimes, would send people out to the funerals of people killed in combat with signs that said things like "God hates fags," which was, and I try to be humorous. There's just no humor to be had in this one. There's no humor to be had. This was extremely distressing to the families who were grieving, usually a young son or daughter who'd been lost in combat, and they had these clowns out there with their "God hates fags" thing. And you may remember that there were a number of attempts to get this conduct to cease, and a lot of them were unsuccessful. There were legislative measures that were taken, and most of them were unsuccessful because of First Amendment grounds. So then you'll recall that there were a number of motorcycle associations that would try to form a kind of physical and decibel barrier between the Westboro folk and the grieving family. It was just a fairly awful situation. And Phelps was, shall we say, rather sweeping in his accusations of having bankrupt values and tolerating homosexuality. Among the people that Phelps made it a point of attacking during the course of his career with Westboro Baptist Church. Now, keep in mind, these are morally bankrupt people in the eyes of Phelps. Ronald Reagan, Princess Diana, Chief Justice William Rehnquist, NFL star Reggie White, Sonny Bono, comedian George Carlin. Carlin would probably be glad to be on the list. The entire LDS Church, murdered college student Matthew Shepard, children's television host Fred Rogers, come on, Australian actor Heath Ledger, Jon Stewart, Stephen Colbert, Bill O'Reilly, Roger Ebert, Catholics, Australians, Swedes, Irish, U.S. soldiers killed in Iraq. I leave it to you to think of any other group in which that collection of individuals was assembled under a common heading. So you guessed it. Little known fact about Fred Phelps. He was also, of course, an attorney, as were several of his children. And what's interesting about Phelps' law practice is he was a civil rights lawyer. And he made quite a career in the early days of bringing suits, including originally one styled Evelyn Renee Johnson versus Topeka, Kansas Board of Education, that were attempting to enforce the integration that was ordered by the U.S. Supreme Court in the Brown v. Board of Ed case. And so what Phelps was alleging on behalf of his clients was that the Board of Education of Topeka, which was obviously an easy target, it was the direct party in the Brown decision, that the Board of Topeka had not expeditiously moved to follow the directives in the Supreme Court's 1954 ruling, that it had not yet made its schools equal, and that by attending Topeka's predominantly minority schools, not segregated anymore after Brown, but predominantly minority, African American students had received an inferior education, and so our friend Minister Fred actually served as at least one significant catalyst of provoking a national debate about getting, let me find a polite phrase, getting municipalities and governments up and moving, and that all deliberate speed did not mean all deliberate delay. Phelps also had some other interesting frolics and detours as a lawyer. He sued President Ronald Reagan while Reagan was in office, alleging when Reagan appointed an ambassador to the Vatican that it was a violation of the constitutional separation of church and state to appoint an ambassador to the Vatican. That was a non-starter. But none of these things were the reasons for Phelps' disbarment. None of these things. The bar never took action against him for any of them. You know, one could make an argument, I suppose, that and by the way, I'm not suggesting anything he did on behalf of integration of schools was a reason for disbarment. That was certainly not the case. But what I'm suggesting that his public positions against the individuals and groups of protected classes that I mentioned would certainly, I think, be worthy of a bar's consideration. What you'll see is a theme where in some of our past programs we've talked about a few individuals who've been disbarred for conduct that did not occur while in the practice of law. And certainly criminal felony conduct like embezzlement, even if it didn't occur in the practice of law, it was properly viewed in most cases as having a bearing on one's fitness, right, to practice law. But no, Fred Phelps actually got disbarred for a very quixotic reason, and of course his activities outside the practice of law, one can't help but think may have had some bearing on this. But here's what happened. A formal complaint had been filed in 1977 against Phelps by the Kansas State Board of Law Examiners because of his conduct during a lawsuit against a court reporter named Caroline Brady. Now, Brady had committed the intolerable offense of failing to have a transcript that Phelps had ordered prepared ready on the day he asked for it. And although reportedly that delay that was unacceptable to Fred Phelps did not affect the outcome of the case in which the proceeding was held, Phelps nonetheless sued this poor court reporter for $22,000, took the case to trial, put court reporter Brady on the stand for a week, footnote, what the hell was the judge thinking, end footnote, declared her a hostile witness, accused her while she was on the stand of being, quote unquote, a slut, tried to introduce testimony from her former boyfriends, second footnote, really, what the hell was the trial judge thinking, end footnote, and then accused her of a variety of perverse sexual acts, leading to her to break down in tears on the stand, another footnote, see footnotes 1 and 2, ante. And back up. And then he then appealed, of course, after losing the trial. And he presented to the court affidavits of 8 witnesses whose testimony, he said, would convince the court to rule in his favor, presumably if those witnesses' testimony had been had been allowed into evidence. I can't think of any other reason why. But where Phelps went wrong was the witnesses actually later testified that they had never been contacted by Phelps, and they had no reason to testify against Caroline Brady. Oops. So Phelps was found to have made false statements in violation of Kansas disciplinary rules of the bar, and he was permanently disbarred from practicing law in Kansas, although he continued to practice in the federal courts. And flash forward 8 years, count them, 9 federal judges filed then a disciplinary complaint against Phelps and 5 of his children, who must also have been lawyers. Why else a disciplinary complaint? And by the way, he had plenty to choose from. He had something like 16 children, if I recall. I may be off by a few, but that's pretty close. The allegations in federal court were that he'd made false accusations against judges, and ultimately those charges were resolved by an agreement by Phelps to cease practice in federal courts permanently. And in closing, I'll deliver the sad news to you that Mr. Phelps passed away in 2014, and I'm sure he's dearly missed by somebody. On a more interesting note, perhaps, I next offer to you Abraham J. Isserman. And I find this interesting, and you'll recall some of my prior comments about in some cases, people argued, perhaps with good reason, that the reasons for professional actions taken against them were due to the clients or causes whom and which they represented. And Isserman is such a person. Isserman died in 1988, and I want to be very, very clear. Isserman was never charged or convicted of any crime or any of the sort of impropriety of people like we've spoken of before. Isserman instead was an American lawyer and activist in Manhattan, New York. He was a prominent leader of the Communist Party of the United States in the 1940s. He defended Gerhard Eisler in trial in something called the Foley Square trial, which focused on Communist Party activities in the United States. Eisler had been accused of being a mastermind for the Soviet spies in the U.S. Life magazine in 1947 ran a story about Eisler, accusing him of being a international communist agent. And the subtext was, boy, and talk about potential pretrial possibility of prejudice. It read, prototype of a professional Moscow school revolutionary. He is now charged with conspiracy against the government of the U.S., end quote. Well, the trial of these Foley Square defendants went on in 1947 before Judge Harold Medina. And during the trial, it was obviously not going well. Isserman stated in open court, I charge that this whole procedure is in bad faith and savors to me of something more, end quote. Eisler, for his part, apparently agreed the trial wasn't going well. During the trial, he skipped bail and fled the country by means of a Polish freighter. You will recall that Poland was part of the Soviet Union, although probably not voluntarily, so I leave that to the historians. Anyway, following appeal of the conviction, Isserman and his colleagues were accused Judge Medina of improperly favoring the prosecution. And Isserman and a fellow defense attorney were held in contempt of court for statements they made about the judge. Isserman went to jail for 4 months. In 1954, he was disbarred from the practice of law in the state of New Jersey, and then he was disbarred from the Supreme Court of the United States. But here's what's interesting. In 1961, the New Jersey Supreme Court voided the disbarment and had his license restored to him. And within the space of 2 minutes, I'm going to tell you why. The New Jersey Supreme Court, long renowned as being one of the more progressive and intellectual state highest courts in the United States, said, and this is all a quote from here until I tell you it's not, In essence, the petition claims disbarment was too harsh a punishment and seeks a reappraisal. Such petitions rarely succeed. The reason that we disbar only if thoroughly convinced of the misconduct reveals a lack. The reason is that we disbar only if thoroughly convinced that the misconduct reveals a lack of the required trust and responsibility. Ordinarily, we should entertain an application only upon a showing of impressive circumstances unknown to the judges who rendered the verdict. We are satisfied that this case meets the standard we have described. We would have a different case here if the record stood that Isserman with others entered into a deliberate conspiracy or plans to obstruct justice. But that charge has been found by the Court of Appeals to lack support in the evidence, and again in the disciplinary proceedings it was found not to be proven. What remains is a finding that he was guilty of several unplanned, contumacious outbursts during a long and bitter trial. Perhaps consciousness of our own short patience makes us unduly considerate of the failing tempers of others of our contentious craft. But to permanently and wholly deprive one of his but to wholly deprive one of his profession at Isserman's time of life, and after he has paid so dearly for his fault, impresses us as a severity which will serve no useful purpose for the bar, the court, or the delinquent. End quote. It was rather nice, and I think it says a lot, and hopefully some judges still feel that way. All right, so next offered for your pleasure and consideration is Charles Kushner. He is a disbarred former attorney and real estate developer. He founded Kushner Companies in 1985. His son Jared is also the husband of Ivanka Trump and the son-in-law of former President Donald Trump. Kushner had been subject to some scrutiny. As far back as 1988, he met personally with the president of Harvard University, and he donated $2.5 million to Harvard. And you'll be shocked and amazed that his son Jared, who was in his senior year of high school at the time, was subsequently admitted in the freshman class of 1999. I'm sure that was entirely on the merits, and I certainly don't mean to imply otherwise about the then president of Harvard University. In any event, Kushner graduated from the Hofstra University School of Law in 1979. Hofstra is located right alongside the Long Island Expressway and actually has some pretty darn good graduates. I'm not sure Kushner was one of them. In 1985, Kushner began managing his father's portfolio of about 4,000 apartments in New Jersey, founded the Cushman Companies, headquartered in Florham Park, New Jersey, was its chairman. In 1999, he won Ernst & Young's New Jersey Entrepreneur of the Year Award. At that point, his portfolio had grown to more than 10,000 residential apartments, a home building business, commercial and industrial properties, and a bank. On June 30th of 2004, Kushner was fined $508,900 by the FEC for contributing to Democratic political campaigns. Footnote, interesting. Democratic political campaigns in the names of his partnerships when he lacked authorization to do so. In 2005, following an investigation by the U.S. Attorney's Office for the District of New Jersey, then U.S. Attorney Chris Christie negotiated a plea agreement with him, under which Mr. Kushner pled guilty to 18 counts of illegal campaign contributions, tax evasion, and witness tampering. You will recall that during that period in time, later Governor Chris Christie was the United States Attorney for the District of New Jersey. Skipping forward about 10 plus years, you will recall that Mr. Christie was reportedly desirous of obtaining a senior position in the new Trump administration. You will further recall that no such appointment was made, and I will leave it to everybody's collective imaginations as to why. So, illegal campaign contributions, tax evasion, and witness tampering. We've covered the campaign contributions. I'm not going to bother with the tax evasion. The witness tampering bears note. The witness tampering charge came out of Kushner's act of retaliation against his brother-in-law, William Schulder, his sister Esther's husband, who had been cooperating with federal investigators in their investigation of Kushner. The finding was that, the plea agreement, Kushner pled to it, so I'm sure he's got lawyers by the barrel, but he can't have any gripe about something he put in a plea agreement. It was found that he hired a prostitute to seduce his brother-in-law, William, arranged to record a sexual encounter between his brother-in-law and the prostitute, and then had the tape sent to his sister Esther as revenge against his brother-in-law. Charles, Jared's father, did I mention that? Okay, was sentenced to 2 years in prison. He served 14 months at the federal prison camp in Montgomery, Alabama, was sent to a halfway house in Newark, New Jersey, and was released from prison in August of 2006. As a convicted felon, he was disbarred from the practice of law in New York, New Jersey, and Pennsylvania. He was pardoned on December 23, 2020, Merry Christmas, in the waning days of Donald Trump's term, Trump citing his record of reform and charity. The Star-Ledger called it an empty pardon that carried no moral weight. Thomas Joseph Capano, former Deputy Attorney General of the state of Delaware. Came from a prominent family of Delaware real estate developers and building contractors. Became a wealthy, well-connected lawyer, state prosecutor, city attorney, legal counsel to the then governor, and a political consultant well known in Delaware's political community. He became a partner in the Wilmington office of a prominent national law firm who has done nothing to deserve mention here. And though married at the time with 4 daughters, he became involved with 28-year-old Anne Marie Fahey, who was the appointments secretary to the governor of the state of Delaware. And then Thomas Capano separated from his wife the following year. And so Fahey began a relationship with somebody else while she was involved with Capano. And she was last seen alive on June 27, 1996, when she went to dinner with Capano in Philadelphia. Family reported her missing. Extensive investigation into which the FBI joined in July of 96 led to a federal grand jury which heard over a year of evidence. And Capano, who was the last known person to have seen her alive, was the primary suspect. He was arrested for her murder in November of 1997, over 16 months after her disappearance. Prosecutors were never able to establish the cause or manner of poor Anne Marie Fahey's death, and her body was never found. So how did he get convicted? He got convicted because prosecutors put on evidence to suggest that Capano had murdered his mistress, poor Miss Fahey, at a house he'd rented, and with the assistance of her brother, had gone out with, his brother, that Thomas Capano, with the assistance of his brother Jerry, had gone out on Jerry's boat and had weighed down her body and dumped it in the sea. And when Jerry later sold his boat, it was noted that the boat was missing its 2 anchors. I will leave that to you as to whether you think there's any probative value there. Anyhow, don't bother spending much time guessing. In November of 97, Capano's brother Jerry was interviewed by detectives, told him Thomas had borrowed the boat, and admitted later that he'd murdered somebody who was attempting to extort him, that he took the boat to Stone Harbor, New Jersey, had Fahey's body in a cooler, sailed 62 miles out to sea, pushed the cooler overboard. The cooler, according to Jerry, did not sink. So Thomas took a bunch of gunshots at it, still remained afloat. So he then retrieved the cooler, removed the body, wrapped the body in the anchors and chains, and dumped it back into the ocean. And Jerry says that Thomas Capano then asked him to help dispose of a blood-stained sofa and carpet, which a third brother, Louis, allegedly helped out with. So this all was pretty much good enough for the jury. After a 12-week trial, the defense put on a claim that another person involved with Fahey had burst into a room while Fahey and Thomas were in flagrante delicto, and then there was wrestling for a gun and a shooting occurred. But the jury disposed of that pretty quickly. And in January of '99, Thomas Capano was convicted of first-degree murder and was sentenced to death by lethal injection. The death penalty sentence was subsequently reversed on appeal because it had been reached by a non-unanimous jury. And the state later abandoned its efforts to seek capital punishment, leaving Capano in prison for life without parole. And he's exhausted his appeals. He's exhausted other stuff too. In 1961, he was found dead in his jail cell. Strike that. In 2011, at the age of 61, he was found dead in his jail cell during a routine security check. The finding was he had died of sudden cardiac arrest. There is not reported how his body was disposed of, and I'll leave it to the humorists to come up with some suggestions. Last on our list today, Lawrence Cantor and Martha Siegel. Lawrence Cantor and Martha Siegel were partners in a husband and wife firm of lawyers who posted the first massive commercial Usenet spam back in 1994. And this came shortly after the National Science Foundation lifted its then existing unofficial ban on commercial speech on the internet. And this spamming activity that Mr. Cantor and wife partner Ms. Siegel engaged in was known as the green card spam. It's believed to have been the first commercial Usenet spam. And these two attorneys are cited as having set the precedent for the modern global practice of spamming. In 1984, they had engaged the help of a Phoenix, Arizona programmer to generate advertisements for their service by enrolling people in a green card lottery. You know, by the way, thanks a bunch. This is like when you buy a house and you receive the solicitations in the mail to establish a homeowner's exemption, which is something you can do completely yourself in about the same amount of paperwork. So anyway, people were encouraged to enroll in a green card lottery. The green cards are just like what they sound. They really are a lottery and a very high odds lottery at that, to get potential non-citizen residency and work permits in the United States. These two nice lawyers offered to do the green card paperwork for a fee. I can tell you from experience when I worked in D.C. that the government goes out of its way to make this kind of paperwork something that an unrepresented person can do by themselves. It's considered to be comme il faut, or for the non-French speakers, it's considered to be kind of nice and appropriate to allow people to be able to complete paperwork as easily as possible, particularly in that kind of circumstances. So anyhow, these lawyers obviously thought they were onto a good thing. They created a company called CyberCell. They promoted themselves as experts in the new business of online retail, and they published a variety of publications on how to engage in similar conduct. In '97, Cantor was disbarred in part for illegal advertising practices, and a member of the Tennessee Board of Professional Responsibility said it was, to his knowledge, the first time a lawyer had been disciplined for internet advertising practices. And so I want to thank everybody for being with us today. You know, these are sad stories at heart. I've attempted to inject a little bit of humor where it seems appropriate. A lot of it's not funny at all. It's not funny certainly not funny to the victims. It's not funny to the people of the city of Detroit. It's not funny to the poor people of Bridgeport, Connecticut. It certainly wasn't funny for the people who attended funerals at which the Westboro Baptist Church showed up. None of it was really funny at all. So go forth and do not likewise. And thank you for your time.